The legal letter arrived on a Tuesday morning, and I knew it was trouble before I even opened the envelope because it had that thick, expensive paper that screams lawyers and money. My name is Xavier Prescott, and I had been living in Meadowbrook Estates in Boulder, Colorado, for exactly 8 months when my relationship with the Homeowners Association went from mildly annoying to outright war. The white envelope sat on my kitchen counter while I poured my coffee, and I stared at it like it might bite me. The return address confirmed my suspicions. Meadowbrook Estates, HOA. Attention Veronica Anderson, President. I opened it standing up, which turned out to be a mistake because I nearly dropped my mug when I read the words cease and desist in bold letters at the top. The letter informed me, in the most condescending legal language possible, that my recently installed wind turbine violated Section 4.7 of the HOA covenants regarding unsightly structures that diminish property values and disrupt the aesthetic harmony of the community. I had 30 days to remove it or face daily fines of $500, plus potential legal action. I read it 3 times, feeling my blood pressure rise with each pass. The wind turbine in question was a beautiful piece of engineering, a small residential model I had installed on my property specifically because Boulder has excellent wind conditions, and I wanted to reduce my carbon footprint. I had done my research, pulled the proper permits from the county, and even hired a structural engineer to ensure everything was up to code. The turbine stood about 40 feet tall on the back corner of my 2-acre lot, humming quietly as it generated clean electricity. What the letter failed to mention was that I had explicitly asked about renewable energy installations before I purchased the house. The real estate agent had assured me there were no restrictions. I had even reviewed the HOA documents, which were admittedly vague about such things, but nowhere did they specifically prohibit wind turbines. Section 4.7 talked about structures, but it was clearly written with things like sheds and gazebos in mind, not renewable energy systems. I grabbed my phone and called my lawyer, Marcus Chen, who had handled my home purchase. He listened while I read him the letter, and I could hear him typing on his computer. Okay, Xavier, first thing to understand is this is just a threat. They cannot actually fine you without following proper procedures, which includes a hearing. Second thing, Colorado has pretty strong renewable energy rights laws. Let me look into this and get back to you. How strong are we talking? Strong enough that HOAs generally cannot prohibit solar panels. Wind turbines are a bit more of a gray area, but you have a good case, especially since you got county approval. Sit tight and do not respond to this letter yet. Let me handle it. I tried to take his advice and stay calm, but 20 minutes later, my doorbell rang. I opened it to find Veronica Anderson herself standing on my porch, dressed in an expensive pantsuit, despite it being 9 in the morning on a Tuesday. She was exactly what you would picture when someone says, HOA president. A woman in her late 40s with an angular haircut and the kind of smile that never reaches the eyes. Mr. Prescott, I wanted to follow up on the letter you should have received this morning. I got it. My lawyer is reviewing it. Her smile tightened. There is really nothing to review. The covenant is quite clear. That monstrosity needs to come down. That monstrosity is a legally permitted renewable energy system on my private property. Your private property is part of Meadowbrook Estates, which means it is subject to our rules. Rules that every homeowner agreed to when they purchased here. I leaned against my door frame, trying to keep my voice level. Veronica, I specifically asked about this before I bought. Nobody said anything about restrictions on renewable energy. Perhaps you should have asked more specific questions. The covenant clearly states that any structure that negatively impacts property values requires board approval. You never sought approval, because I didn't think I needed it. It's not a structure in that sense. It's an energy system, same as having a breaker box or a meter. She pulled out her phone and showed me a photo. It was my wind turbine, taken from what must have been several houses away. Does this look like a breaker box to you? I have had 3 complaints from neighbors already. The spinning blades are distracting, the noise is disturbing, and frankly, it makes our community look like some kind of industrial park. The turbine is virtually silent from more than 50 feet away, and it is on the back corner of my lot, barely visible from the street. I can see it from my kitchen window, Mr. Prescott. That makes it my problem. You have 30 days. She turned and walked away before I could respond. I called Marcus back immediately. He sighed when I told him about the visit. She is trying to intimidate you. It is a common tactic. Do not let it work. I am going to draft a response citing Colorado's renewable energy laws and your county permits. In the meantime, document everything. If she shows up again, make notes of what she says. Keep that letter in a safe place. The next day, I received an email from the HOA secretary with minutes from an emergency board meeting that had apparently taken place the previous evening. The entire agenda had been my wind turbine. The board had voted unanimously to pursue all available legal remedies to force its removal, and authorized spending up to $50,000 on legal fees if necessary. I realized then that this was not going to be a simple disagreement. Veronica had money and time, and she clearly saw my turbine as some kind of personal affront. Over the next week, things escalated. I received a second letter, this one even more threatening, claiming that my turbine violated noise ordinances, despite the fact that I had measurements showing it produced less than 30 decibels at the property line, well below any threshold. I got a notice that my trash cans had been left out past the allowed time, which was technically true by about 15 minutes, resulting in a $50 fine. Another notice arrived claiming my lawn was too long, even though I had mowed it 3 days earlier. It was clear Veronica had decided to make my life miserable in every way possible. Then things got interesting. My property had a unique feature that I had not thought much about when I purchased it. The previous owner had installed a small utility easement that ran across the back corner of my lot. This easement carried electrical lines that serviced 3 houses on the other side of a small ravine. Houses that technically had access through another street, but whose electrical service was most efficiently routed through my property. The power company had an easement, meaning they had the legal right to maintain the lines, but I owned the land beneath them. What made this relevant was that one of those 3 houses belonged to Veronica Anderson. I discovered this while reviewing my property documents, looking for anything that might help my case. The plat map clearly showed the electrical easement, and the county records confirmed which properties it serviced. I called Marcus immediately. Is there any way to revoke an easement? He paused. That is a complex question. Generally, no, easements run with the land, but there are circumstances where they can be challenged or modified. Why? I explained the situation. He was quiet for a long moment. Xavier, I understand you are frustrated, but you need to be very careful here. Interfering with electrical service could open you up to serious liability. I am not talking about cutting power. I am just asking about the legal framework. The power company has the easement, not the individual homeowners. So even if you could somehow challenge it, you would be fighting the utility company, not Veronica, and you would lose. But what if the easement was granted voluntarily by the previous owner? What if it was not a mandatory utility easement, but rather a private agreement? More typing sounds. Let me look into this. Send me everything you have on that easement. I scanned and emailed him all the relevant documents, then spent the rest of the evening researching Colorado property law. What I found was interesting. The easement had indeed been granted voluntarily by the previous owner in 1998, shortly after the neighborhood was developed. It was not a utility company easement in the traditional sense, but rather a private easement that allowed the utility company to run lines across my property to service those 3 houses. Private easements could, under certain circumstances, be challenged or revoked, especially if the party benefiting from the easement engaged in behavior that constituted abuse or bad faith. Marcus called me back at 10 that night. Okay, this is fascinating. The easement is private, granted by your predecessor in interest. Theoretically, you could challenge it, but you would need to show that the terms have been violated or that continuing the easement would create an undue burden. It is a high bar. What if I just refuse to allow access for maintenance? Then the power company would sue you and get a court order. You would lose and probably pay their legal fees. Xavier, where are you going with this? I told him my idea. He was silent for a long time. That is probably the most creative and potentially disastrous thing I have heard all year. If you do this wrong, you could face criminal charges, civil liability, and basically destroy any chance you have of winning the turbine dispute. But if I do it right, another pause. If you do it exactly right, following every legal requirement and procedure, you might be able to create enough leverage to force a settlement. But it is incredibly risky. More risky than spending years in litigation with an HOA that has unlimited funds and a personal vendetta. Point taken. Let me research this more thoroughly. Do not do anything yet. The next morning, I received another letter from the HOA. This one informed me that they had filed a formal complaint with the county, claiming my wind turbine violated setback requirements. I knew this was false because the engineer had been meticulous about setbacks, but it meant I would have to spend time and money defending against the complaint. That afternoon, a county inspector showed up. He was a tired-looking man in his 50s who clearly had better things to do. Mr. Prescott, I am here about a complaint regarding your wind turbine. I showed him my permits and the engineering reports. He walked around the turbine, taking measurements and photos, then checked his tablet. Everything looks fine to me. Your setbacks are actually better than required. Who filed the complaint? The HOA president. He rolled his eyes. Of course. Look, I will file a report saying everything is in compliance. That should end it, but between you and me, HOA disputes are the worst. They never actually end. I am starting to realize that. He left, and I felt a small victory. But that evening, Veronica posted in the neighborhood Facebook group, which I had reluctantly joined when I moved in. Her post claimed that my turbine was a safety hazard, citing debunked studies about wind turbines causing health problems. Within an hour, dozens of neighbors had commented, most of them believing her without question. I tried to respond with facts, posting links to actual scientific studies and my county permits, but I was quickly drowned out. Several people accused me of being selfish and ruining the neighborhood. One person suggested I should be forced to move. That night I called Marcus. I want to move forward with challenging the easement. Xavier, I cannot in good conscience recommend this without being very clear about the risks. I understand the risks. Walk me through the process. Over the next hour, he explained what would be required. First, I would need to file a formal notice with the power company, stating my intent to challenge the easement. Then I would need to document any violations or burden the easement created. Finally, I would need to demonstrate that I had attempted to resolve the issue through negotiation. The key insight was that I did not actually have to succeed in revoking the easement. I just had to create enough uncertainty and potential delay that Veronica would prefer to negotiate rather than risk her own power service being disrupted during a lengthy legal process. The critical thing is that you cannot actually cut the power or prevent access unless you have a court order allowing it. If you do, you will be facing criminal charges. What you can do is file the challenge and make it clear that you are prepared to pursue it to the fullest extent of the law. What if I offered to drop the challenge in exchange for them dropping the turbine dispute? That would be a settlement negotiation, completely legal and honestly probably your best outcome, but you need to be prepared for them to call your bluff. It is not a bluff. We spent the next 2 weeks preparing. Marcus drafted a comprehensive legal challenge to the easement, citing multiple grounds including changed circumstances, undue burden, and lack of absolute necessity. We documented that the 3 houses could potentially be serviced through an alternative route, though it would be more expensive. We noted that the easement granted in 1998 had not anticipated the kind of renewable energy installations that were now common, and that my use of the property for wind energy generation was incompatible with high-voltage electrical lines running through the same area. That last point was a bit of a stretch, but it was not entirely false. Having power lines near a wind turbine did create some complications, though nothing unsafe. On a Friday afternoon, I hand-delivered the challenge documents to the power company's local office, with copies sent to the HOA and specifically to Veronica Anderson. Marcus had advised doing it this way for maximum impact. The reaction was immediate. Veronica called my phone 6 times within an hour. I did not answer. Then she showed up at my door at 7 in the evening, red-faced and furious. "What the hell do you think you are doing, following legal procedures to protect my property rights? You cannot cut off my power." I am not cutting off anything. I am challenging a private easement that I believe is no longer appropriate given current circumstances. This is extortion. No, this is property law. If you would like to discuss a settlement, I am happy to do so. Otherwise, I suggest you talk to your own lawyer. She was shaking with rage. "You have no idea what you have just started. I will bury you in legal fees. I will make sure you never have a moment of peace in this neighborhood. You have been doing that for weeks already. At least now we are on equal footing." She stormed off, and I closed the door, feeling a mix of satisfaction and terror. I had just declared war on someone with far more resources than I had, and there was no going back now. That weekend, my phone would not stop buzzing. The neighborhood Facebook group exploded with outrage. Veronica had posted a heavily edited version of events, making it sound like I was trying to cut power to 3 families out of spite. People who had never spoken to me before were sending me hateful messages. Someone left a bag of dog waste on my porch, but on Monday morning something unexpected happened. Marcus called me, laughing. "You are not going to believe this. The power company does not want to fight this." "What?" "They looked at the easement, looked at your challenge, and apparently decided it is not worth the hassle. The alternative routing would cost them maybe $20,000, and fighting your challenge could cost more than that in legal fees with no guarantee they would win. They are suggesting a mediation session with all parties to discuss options. So we have leverage. We have more than leverage. We have them motivated to find a solution. This is good, Xavier. Very good." The mediation was scheduled for 2 weeks later. In the meantime, the HOA doubled down on their harassment. I received violation notices for things that were not even violations, My car was keyed in my own driveway, and someone spray-painted "asshole" on my trash cans. I reported everything to the police, who took statements, but said there was little they could do without evidence of who was responsible. I installed security cameras around my property, which immediately paid off when I caught a man I did not recognize taking photos of my house and turbine at 2 in the morning. The cameras also recorded Veronica driving slowly past my house multiple times per day. Marcus advised me to document everything but avoid any direct confrontation. She is trying to provoke you into doing something stupid. Do not give her the satisfaction. The mediation took place at a conference room in a downtown Boulder office building. Present were myself and Marcus, Veronica and her lawyer, 2 representatives from the power company, and a professional mediator. The mediator, a calm woman in her 60s named Patricia Moore, started by explaining the ground rules. We are here to find a mutually acceptable solution. Everything said in this room is confidential and cannot be used in court. I encourage everyone to be honest about their interests and creative about potential solutions. Veronica's lawyer, a sharp-dressed man named Donald Burke, spoke first. Our position is simple. Mr. Prescott installed an unauthorized structure that violates HOA covenants. He then threatened to cut power to 3 homes, including my clients, in retaliation. We are here to resolve the power issue, but the turbine must come down. Marcus responded calmly. Mr. Prescott's turbine is a legally permitted renewable energy system that violates no laws and arguably cannot be prohibited under Colorado statute. The easement challenge is not retaliation, but rather a legitimate property rights issue that exists independently of the HOA dispute. However, Mr. Prescott is willing to discuss reasonable compromises. The power company representative, a tired-looking engineer named Tom Garcia, jumped in. We just want this resolved efficiently. We have looked at alternative routing options. It is feasible but not ideal. We would prefer to maintain the existing easement, but we are not going to spend a fortune fighting about it. Patricia nodded. Thank you. Let me ask each of you, what is your ideal outcome here? Veronica spoke up, her voice tight. The turbine comes down. That is non-negotiable. I shook my head. The turbine stays. That is non-negotiable. Then we have nothing to discuss, Donald Burke said, standing up. Sit down, please, Patricia said firmly. We have not even begun to discuss creative solutions. Mr. Prescott, why is the turbine so important to you? Because I installed it legally, after doing my due diligence, and I should not have to remove a legal renewable energy system just because someone does not like how it looks. It is a matter of principle. Miss Anderson, why is removal so important to you? Veronica's face reddened. Because it is ugly and it makes the neighborhood look terrible. Property values will plummet. People bought here because of the aesthetic standards we maintain. Have property values actually decreased? Patricia asked. Veronica hesitated. Well, no, but they will. Has anyone actually refused to buy a home in the neighborhood because of the turbine? It has only been up for 2 months. Patricia turned to me. Mr. Prescott, would you be willing to modify the turbine in any way? Perhaps paint it a different color or reduce its height. The color is white because that is safest for birds. The height is necessary for proper wind capture and is already at the minimum effective level. I could agree to additional landscaping to screen it from certain angles, but I am not going to compromise its function. Marcus added, we should also note that Colorado law generally prohibits HOAs from banning renewable energy systems. Even if the covenant could be interpreted to apply here, which we dispute, it would likely be unenforceable. Donald Burke shook his head. That law applies to solar panels, not wind turbines. The statute says renewable energy systems, not just solar. Wind is included. They argued back and forth for a while, and I could see Patricia taking notes. Finally, she called for a break and asked to speak with each party separately. When it was my turn, she closed the door and sat across from me and Marcus. Off the record, I think you have a strong legal position on the turbine, but Veronica Anderson is not someone who backs down easily. She will spend every penny the HOA has fighting this, and even if you win, you will be living in a hostile neighborhood with someone who hates you as your HOA president. Is that really what you want? I do not want to be bullied into removing something I legally installed. I understand. Let me ask you this. What if we could get them to agree to not just drop the turbine dispute, but also formally amend the covenants to explicitly allow renewable energy systems? That way, you have your turbine and you have protection for the future. I looked at Marcus, who nodded slowly. That would be acceptable, assuming it is a blanket provision that benefits all homeowners, not just Xavier. And in exchange, I would drop the easement challenge and agree to some reasonable aesthetic compromises, like the landscaping I mentioned. Patricia smiled. Let me see what I can do. The next session was tense. Patricia presented the proposal. I would drop the easement challenge immediately, agree to plant screening trees at my expense, and paint the turbine base a neutral color to blend with my house. In exchange, the HOA would drop all actions against the turbine, formally amend the covenants to allow renewable energy systems subject to reasonable regulations, and issue a public statement clarifying that I had acted legally. Veronica looked like she had swallowed glass. This is rewarding his blackmail. This is resolving a dispute, Patricia corrected. And frankly, Miss Anderson, your HOA is one lawsuit away from discovering that your covenant is probably unenforceable anyway. This way, you get to maintain the easement, avoid costly litigation, and actually improve your covenants to be more modern and legally sound. Donald Burke whispered to Veronica for several minutes. Finally, she spoke. I want approval rights over any future renewable energy installations. The HOA should review each one. Marcus shook his head. No, that is exactly the kind of restriction Colorado law prevents. The covenant can include reasonable standards, like setback requirements, noise limits, and safety specifications, but not approval requirements that could be used to arbitrarily deny applications. More arguing followed, but eventually they reached a compromise. The new covenant provision would allow renewable energy systems that met specific objective criteria, things like minimum setbacks, maximum height limits, noise thresholds, and safety certifications. Any installation meeting those criteria would be automatically approved, but the HOA could require documentation proving compliance. It was not perfect, but it was fair. The power company representative nodded. If everyone agrees, we will maintain the existing easement and drop this whole thing. I looked at Marcus, who gave a slight nod. Agreed. Veronica stood abruptly. Fine, but I wanted in writing that he can never install anything else without proper documentation. That is already part of the agreement, Patricia said. Any renewable energy system needs to demonstrate compliance with the standards, but Mr. Prescott's existing turbine is grandfathered in. We spent another hour hammering out the exact language, with both lawyers drafting and redrafting. Finally, we had a settlement agreement that everyone signed. I agreed to drop my easement challenge immediately, and the HOA agreed to drop all actions against my turbine and call an emergency meeting to vote on the covenant amendment within 30 days. I walked out of that conference room feeling like I had just run a marathon. Marcus clapped me on the shoulder. You did good. That could have gone much worse. Is she going to actually follow through? The agreement is binding. If she does not, we can enforce it in court, and at that point, we would likely get attorney's fees too. She will comply. He was right about the legal enforceability, but he was wrong about Veronica. Over the next 2 weeks, she did everything she could to undermine the agreement without technically violating it. She called an HOA meeting to vote on the covenant amendment, but scheduled it for a Tuesday at 2 in the afternoon, when most people were at work. She sent out a notice to all homeowners describing the amendment in the most negative terms possible, claiming it would allow industrial installations and destroy property values. I found out about the meeting time and showed up, along with about a dozen other homeowners. Veronica looked surprised and annoyed to see me. The meeting was predictably hostile. Veronica presented the amendment as if it were something I had forced upon the community through threats. Several neighbors spoke against it, repeating the same debunked claims about wind turbines. But then something unexpected happened. A woman I had never met, maybe in her 30s with 2 kids, stood up. I have been thinking about installing solar panels. I did not realize the HOA could prevent it. If this amendment means I can finally do that without begging for permission, I am all for it. An older man nodded. Same here. I looked into solar years ago but got discouraged by the approval process. This actually sounds good. Slowly, the tide turned. It helped that Marcus had coached me to bring copies of the actual amendment language, which was far more reasonable than Veronica's description suggested. When the vote was finally called, it passed by a margin of 8-3. Veronica looked furious but had no choice but to record the result. The amendment was now part of the official covenants. I thought that would be the end of it, but Veronica had one more play. 2 days later, I received a letter from the HOA informing me that my annual dues were being increased to $5,000, up from the previous $1,200. The letter explained that this was necessary to cover increased legal expenses related to property disputes. I called Marcus immediately. Can they do this? You have a copy of your HOA bylaws. I found them and read the relevant section. The board could increase dues, but only by a vote of the full membership for increases over 10% annually. They are supposed to have a membership vote. This is just a board decision. Then it is invalid. Send them a letter refusing to pay the increase and citing the bylaw requirement. If they try to enforce it, we will challenge it. I did exactly that, and Veronica responded by putting a lien on my property for unpaid dues. That turned out to be a serious mistake on her part. Marcus filed an emergency motion to invalidate the lien, arguing that the dues increase was improper and the lien was therefore fraudulent. The judge agreed and not only invalidated the lien but ordered the HOA to pay my attorney fees for having to fight it. Even better, the judge specifically noted in his order that the HOA board appeared to be acting in bad faith. That order opened the floodgates. Other homeowners who had been quietly frustrated with Veronica's management style suddenly felt empowered to speak up. Within a month, a group of them organized a recall petition, collecting enough signatures to force a new election for HOA president. Veronica fought it, of course, but she was losing support by the day. The final straw came when someone discovered that she had been billing personal expenses to the HOA. Things like dinners and even a weekend trip to Aspen that she had claimed was for research on HOA management practices. The recall election was not even close. Veronica was removed, and a reasonable guy named Paul Mitchell was elected as the new president. His first act was to reach out to me personally, apologizing for the harassment and promising a fresh start, but Veronica was not done. Apparently, losing the election and the public humiliation had pushed her over the edge. About a week after Paul took over, I was working in my garage when I heard a loud crash. I ran outside to find Veronica attacking my wind turbine with a sledgehammer. "You ruined everything," she screamed, taking another swing at the base. "This is all your fault." I pulled out my phone and started recording while calling 911. "Veronica, stop. You are destroying my property." "Good, it should have never been here," she swung again, denting the metal casing. The police arrived within 5 minutes. By that point, Veronica had caused several $1,000s in damage and was completely incoherent, screaming about how I had destroyed her life and the neighborhood. The officers tried to calm her down, but she took a swing at one of them with the sledgehammer. They tackled her, handcuffed her, and arrested her on the spot. I provided my video evidence, and they took extensive photos of the damage. At the station, they charged her with criminal mischief, a felony due to the amount of damage and assault on a police officer. Her lawyer managed to get her out on bond, but the damage was done. Everyone in the neighborhood now knew exactly what she was capable of. The criminal case took months to wind through the system. I had to testify about the history of our dispute, the HOA harassment, and the events of that day. Veronica's lawyer tried to paint me as the aggressor, claiming I had driven her to a mental breakdown through my aggressive legal tactics. But the judge was not buying it. In the end, Veronica pleaded guilty to criminal mischief in exchange for the assault charge being dropped. She was sentenced to probation, community service, and ordered to pay restitution for the damage to my turbine, which totaled $8,000 after repairs. But the civil consequences were even more significant. The new HOA board, led by Paul, voted to pursue legal action against Veronica personally for her mismanagement and misuse of HOA funds. They discovered that over her 3 years as president, she had improperly spent more than $30,000, money that needed to be repaid. Several homeowners, myself included, also filed a joint civil suit against her for harassment and abuse of authority. That case was still pending, but our lawyer was confident we would prevail. Meanwhile, life in Meadowbrook Estates actually improved dramatically. Paul turned out to be an excellent HOA president, focused on actual community improvement rather than petty enforcement. He organized neighborhood events, got the common areas properly maintained, and generally ran things efficiently. My wind turbine continued spinning quietly on my property, generating clean electricity, and serving as a reminder that sometimes you have to stand up for what is right, even when it is difficult. Several other neighbors ended up installing solar panels, taking advantage of the amended covenants. About 6 months after Veronica's arrest, I was in my backyard doing some gardening when Paul stopped by. We had become friendly, occasionally having beers together and talking about the neighborhood. "Thought you would want to know," he said. "Veronica and her husband are selling their house. They are moving out of state." "Really?" "Yeah. I think between the criminal case, the civil suits, and everyone knowing what happened, she just could not handle living here anymore. Their house goes on the market next week." I felt a strange mix of emotions. I had never wanted to destroy anyone's life, but Veronica had made choices that led to consequences. That is probably for the best. Fresh start for everyone. Agreed. Hey, speaking of fresh starts, we are having a neighborhood barbecue next weekend. You should come. Bring that girlfriend of yours. I had started dating someone, Emily, about 2 months earlier. We had met at a renewable energy conference, which felt appropriately ironic. We will be there. The barbecue was fun, and I was struck by how different the neighborhood felt without Veronica's toxic presence. People were friendly, relaxed, actually enjoying each other's company rather than living in fear of the next violation notice. As I stood there, watching my wind turbine spinning lazily in the evening breeze while kids played in the cul-de-sac and neighbors laughed together, I reflected on everything that had happened. It had been exhausting, expensive, and at times frightening. But I had learned something valuable about standing up for yourself, about not backing down when you are in the right, and about the importance of having good legal counsel. Marcus had ended up becoming a good friend through all of this, and he later told me that my case had inspired him to specialize in HOA law, particularly helping homeowners defend their rights. He now had several clients fighting similar battles, and he credited my willingness to take risks as giving him the framework for how to approach these disputes. The criminal charges against Veronica became a matter of public record, and the local newspaper even did a story about HOA overreach, using my situation as the primary example. The article prompted some state legislators to introduce a bill that would strengthen homeowner protections and limit HOA authority, particularly regarding renewable energy installations. Emily turned out to be amazing. She was an environmental engineer who completely understood why I had fought so hard for the turbine. We would sometimes sit on my back porch, watching it spin, talking about sustainability and property rights and the intersection of personal freedom and community standards. One evening, about 8 months after the mediation, she asked me if I thought it had all been worth it. The fight, the stress, the money, everything. Was it worth it for a wind turbine? I thought about it for a moment. It was never really about the turbine. It was about not being bullied, about standing up when someone tries to use arbitrary power to control you. If I had backed down, Veronica would have just found something else to attack. Someone had to draw a line. And you are glad it was you. I am glad it is over. But yeah, I am glad I fought. This neighborhood is better now because someone stood up to her. Other people feel empowered to install renewable energy because I fought for that right, and I learned a lot about myself in the process. She smiled and kissed me. Good answer. The civil suit against Veronica eventually settled. She agreed to pay $40,000 to be distributed among the plaintiffs and the HOA, and she signed an agreement never to serve on an HOA board again. Her husband, who I had barely ever met, apparently filed for divorce shortly after they moved to Arizona. I heard through the neighborhood grapevine that the stress of everything had destroyed their marriage. I did not take any satisfaction in that. My goal had never been to ruin her life, just to protect my own rights. Paul proved to be exactly the kind of leader the community needed. Under his management, the HOA became what it should have been all along. A group of neighbors working together to maintain common areas and handle shared concerns, not a miniature dictatorship enforcing petty rules. The wind turbine became something of a neighborhood landmark. Kids would point at it when they rode their bikes past my house. During a bad storm, when parts of Boulder lost power, my house stayed lit, and I was able to run extension cords to help a few neighbors keep their refrigerators running. That did more to win people over than any legal argument ever could. 2 years after the initial cease and desist letter, I was doing a routine inspection of the turbine when a car pulled up. A young couple got out, looking nervous. "Are you Xavier Prescott?" the man asked. "I am." "We are thinking about buying in the neighborhood, a few streets over. Our realtor mentioned you have a wind turbine and that there was some drama about it. We are really interested in sustainable living, and we wanted to know if the HOA would give us trouble if we wanted to install solar panels." I smiled and invited them to look at the turbine, explaining the whole story, the initial fight, the legal battle, the covenant amendment, and the current state of affairs. They listened, fascinated. "So the HOA is actually supportive now?" the woman asked. "Very much so. We have about 6 houses with solar now, and the new president is great. Honestly, it is a good neighborhood. It just took some growing pains to get here." They thanked me and left, and I later heard they bought the house. Over the next year, they installed a comprehensive solar array, and we became friends, occasionally getting together to talk about renewable energy and share data on our system's performance. My legal bills had ended up totaling around $30,000, which was painful but not devastating. The settlement money helped offset that, and more importantly, my electricity bills had dropped to almost nothing. The turbine paid for itself faster than I had projected, and I calculated that it would be cash flow positive within 7 years total, accounting for all costs including the legal fees. But the real value was not financial. It was living in a community where I felt respected, where my rights were protected, where I could make choices about my own property without fear of arbitrary retaliation. That was worth far more than money. Marcus and I stayed in touch, meeting for lunch every few months. He told me that my case had become something of a legend in HOA law circles, cited in several legal briefs as an example of effective property rights enforcement. "You know what the best part is?" he told me over sandwiches one day. HOA lawyers now think twice before filing actions against renewable energy systems. They know that homeowners might actually fight back and that the law is not on their side. "You created precedent, not in court but in practice." "I just wanted to keep my turbine," I said. "And you did. But you also changed how HOAs approach these disputes. That is not nothing." Emily and I got engaged about 2.5 years after we met. We decided to stay in the house, in the neighborhood that had caused so much stress but had ultimately become a real home. We talked about adding solar panels to supplement the wind turbine, creating a hybrid system that would make us completely energy independent. The planning for our wedding coincided with Paul announcing he would not run for re-election as HOA president. He had done a great job for 3 years, but he and his wife were expecting their first child and he wanted to focus on family. Several people approached me about running. I was hesitant at first, but Emily convinced me to do it. "You fought to make this community better," she said. "Now you have a chance to help lead it. Why not?" I ran unopposed and won easily. My first act as HOA president was to formally recognize Paul for his service and to reaffirm the community's commitment to reasonable governance. My second act was to propose a sustainability initiative, offering to help any homeowner who wanted to explore renewable energy options. We brought in experts to do free consultations, and I shared my experiences and data freely. Within a year, we had 12 houses with solar installations, 2 more considering wind turbines, and the community's aggregate carbon footprint had dropped significantly. The neighborhood newsletter, which under Veronica had been mostly violation notices and complaints, became a forum for sharing ideas, celebrating achievements, and actually building community. We started a tool library, organized neighborhood cleanup days, and created a community garden on an unused common area. One evening, about 4 years after that first cease and desist letter, I was adjusting something on the turbine when an older neighbor named Frank walked over. He had been one of Veronica's supporters initially, and we had not spoken much since then. "Xavier, got a minute?" he asked. "Sure, what is up?" He looked uncomfortable. "I wanted to apologize. When Veronica was going after you about this thing, I signed one of her petitions. I did not really understand what was happening. I just believed what she said about property values and all that." "Frank, it is okay. That was a long time ago." "No, let me finish. I have been watching what you have done, both with this turbine and as HOA president. This neighborhood is better now. My electric bills have gone down since I installed those panels, and my grandkids think it is really cool that Grandpa is helping the environment. I was wrong to oppose you, and I wanted you to know that. We shook hands, and I was surprised by how much that meant to me. It was not about being right or winning. It was about people understanding and the community coming together. That night, I sat on my back porch with Emily, both of us watching the turbine spin against a spectacular Colorado sunset. My phone buzzed with an email. It was from a homeowner in California, someone Marcus had referred to me, asking for advice about fighting their HOA over a solar installation. I wrote back, sharing my story and offering encouragement. Over the past few years, I had heard from dozens of people in similar situations, and I tried to help when I could. Some fights were won, some were lost, but at least people knew they did not have to just accept arbitrary authority. Emily leaned her head on my shoulder. What are you thinking about? How different things are now compared to 4 years ago. How much stress and anger there was, and how it all seems almost unreal now. Any regrets? I watched the turbine blades catch the last rays of sunlight, spinning steadily, generating clean power, standing as a symbol of both sustainable energy and the importance of standing your ground. Not even one. The turbine continued to spin, just as it does today, a quiet reminder that sometimes the right thing to do is also the hard thing, and that communities are stronger when built on principles of fairness and respect, rather than arbitrary power and fear.